Hi, my name is Prashant Khanna and I'm an advocate on record in Supreme Court of India. And in this video, I'm going to talk about a very important topic related to income tax. People generally file income tax and there is a self-assessment process where your chartered accountant will be assessing that what income tax you are required to pay depending on various expenses or the income that you have done in the last assessment year. Now, this thing is since self-assessed, therefore there is a provision in Income Tax Act which provides that if the income tax department or the ITO, that is the income tax officer, finds that you have escaped some income and not got assessed yourself for that income for the payment of the tax, then he may open the assessment of the tax for that very particular financial year in which you escaped some income, meaning thereby that if even after filing of the income tax return, if there is any manipulation or if there is any hiding of the income from the SSC, then to the this income tax department can always come and open your previous assessment ITR, and then they can impose. First they will collect the tax that is due to be filed by you or that was less filed by you or paid by you, and then there would be a penalty also of up to 200%, and then there will be interest also. However, the law has provided certain limitation to this. Limitation is with respect to number of years, that up to how many previous years one can go and open the reassessment. Generally, it is up to 10 years. However, as they go back and as the amount increases, the ITO has to take prior permission from his senior officers, which may be the commissioner income tax or the principal chief commissioner of income tax. So there are different slabs for which they have to take the required permission. Now, what is the requirement or the procedure that the income tax officer has to follow for taking this process of reassessment of tax? So if let us say that the income tax officer, through various system that the Department of Revenue has established, be it the Insight portal or be it different uh, reporting mechanisms or the systems that they have established, and they get to know, let us say that you had 3 or 4 bank accounts and you disclose the income only from 1 or 2 bank accounts, and the income in other bank accounts were left undisclosed. Or let us say that you did not disclose the interest that you earned from certain uh, derivatives or certain other instruments, interest bearing instruments that you had. Or let us say that you had got a capital gain in that year, you sold some property and you did not disclose the capital gain. So any kind of non disclosure of the income, the ITO will issue a notice wherein he will have to specifically mention that for which year he is opening the reassessment, which was the income that escaped assessment, and why does he feel that the income escaped assessment and you have not paid the tax. If all these requirements are there, then you will have to reply to that notice. This notice by the income tax officer is issued under section 148A of the Income Tax Act, and you have to reply to that notice, and in that you have to mention that how the income that he is claiming to have escaped or have not been taken into consideration for calculating your income, and you will have to prove that no, it has not escaped assessment, rather it was calculated some other manner, or how that income is not an income but it is something else. So you'll have to take the help of the law of the income tax itself, and you have to give explanation to it. There is another option that you can take here, is that you can approach High Court for getting the notice quashed, but for that you will have to prove certain things like um, violation of principle of natural justice, or you will have to prove that the notice has been issued without jurisdiction if you are challenging the notice under section 148A. Now, If you chose to reply to section 148A notice and give explanation, all detailed explanation of the notice, and let us say that still the income tax officer is not satisfied and he still prefers issuing a notice under section 148, or the he passes an order under section 148 of the income tax act and determines that yes, you have really uh, you really hid your income and that income needs to be assessed and then tax needs to be imposed on that, and he has not taken or he did not consider any of your replies. In that scenario also, you get an additional ground for challenging the 148 order and before the honorable high courts under article 226 by means of a writ petition. So here you will have various grounds that your, let us say, grounds were not taken into consideration. There has been absolute no application of mind, or there can be that he did not have the authority or jurisdiction, or the income which escaped assessment was beyond the limitation that is provided under the law, or there can be many other circumstantial situations in the past also. Like I'll give you some examples. Like many a times what happens that they go for assessment of income of a dead person of a particular year, and they go against the legal heirs. In that scenario also, reassessment may not be possible depending on facts and circumstances. There may be a situation where there may be overlapping of the names, similar names may be there but there may be different PAN numbers, and then there may be a issue that a reasonable time was not granted to you for giving the full disclosure or full explanation. Let us say ki, under section 148 a, a time period of only 5 days, 6 days or 7 days was provided, and you were not able to collect documents from your bank or the financial institution, or the documents related to the income which it is talking about, which the notice is talking about. So there has to be a reasonable time also that is required to be provided to you for actually replying to the notice that you are taking. Other ground that can be there is that the notice does not disclose actually the foundation which connects or which has the nexus with the income which the income tax officer is claiming to have escaped assessment. These are certain grounds on which you can approach High Court. Depending on facts and circumstances of your case, you can consult your advocate and the CA and decide whether you want to approach the Honorable High Court or not. In High Courts, generally you may get a relief if you can prove all these limited things. Number one, that the procedure which was prescribed in the law is not being followed. Number two, that there is principle of violation of natural justice, or the reply furnished by you has not at all been considered by the assessing officer while passing the order under section 148, or that the IT or the income tax officer who issued the notice to you lacked the jurisdiction, or that he did not take the permission from the higher authorities, or that the assessment year is time bound because of the limitation. So these are certain grounds, and more grounds can be taken depending on the facts and circumstances of the case. So if you have received any notice under section 148A of the income tax, you need not required to worry, and you can consult your CA or the advocate, and a proper remedy as available under the law may be availed by you. So this is all with respect to how to deal with section 148A notice through High Court under writ petition. Hope this was helpful for you. Thank you so much for watching the video.